all have, that has been exchanged even by Mr. Ndate Semelemecha?
Well, Madam Chair, we are aware that she sought the funding of a council from the Solicitor General, which was refused, and she was directed to use the services of the NPA legal team, and she then appealed to the minister, which appeal was then dismissed. That's all we are aware of. We don't have the details on the documentation itself of that application.
Nothing debars you from communicating with Mr. Semelemecha with regard to that correspondence or all the facts that were presented to him and subsequently to the minister as to whether she explained the reason why she thinks that she's entitled to a personal legal representation as a witness?
Well, Madam Chair, we'll inquire from Mr. Semelemecha. As far as we are aware, Mr. Semelemecha always copies us if she receives correspondence, whether from Advocate Batoi, from Advocate Chauke's team. She communicates, she gives us copies. In this case, or in relation to that, we did not see any correspondence. But I will inquire from him whether he had any access to such correspondence.
Well, he is an instructing attorney here, the Solicitor General. And he must have based his decision, or the state attorney's decision, on the basis of something. The minister, too, must have based her decision on something. And it is therefore that I'm asking you to confer with him. He is your instructing attorney. Then you can get all that information from him. And if such information was presented, which we are not aware of, because we don't have any facts, it may well be that Advocate Batoi presented something that has not been brought to our position, that if you were to apply, you may include in that application. But I'm not very sure whether the relief that you'll seek will be such that may entitle us to direct the minister to afford her legal representation. That's why I was asking you, if you were to apply, and I'm just asking you to assist us, if you were to apply, what kind of a relief are you going to seek, given this background?
Well, Madam Chair, I think I've already tried to answer that question. We have not yet brought the application, of course, and we will consider what Madam Chair is saying, but I think part of the problem is that we also don't have facts precisely for the reason that we are unable to consult directly with Advocate Batoi. But we will consider all that has transpired now and also consider, we have not even, I have not discussed with my team whether we will bring that application as evidence leaders. But we are going to consider that now. Yes.
I suppose it's the right time to pause to enable you to consider your position as regards the matters that we have been engaging with Advocate Skosana on. And when you resume, you will then present your position, covering all the facts that we have been raising with him, because we don't know what the right answer is. We are all taken aback. We don't have answers, and we don't know what kind of ruling or direction we can give in the circumstances, and we will take the matter from there. This, I beg your pardon.
Thank you, Madam Chair.
I beg your pardon. This will also enable all of you, if need be, to confer with Advocate Halley, who's representing the NPA. These are not simple matters to simply discuss, like we are just having a discussion on a matter where there is no application. And that's why I'm asking counsel, given all the circumstances, even if you were to go the route of a substantive application, what kind of a relief would you people ask us to consider? And secondly, whether there is sufficient evidential material presented either before the Solicitor General or the Minister that we ought to consider, even aside of a substantive application. I know that you may not have such information, but if there's anything that can be brought to our attention, probably favorable to Advocate Batoyi, it should be brought to our attention. That Melmecha is here. He signed one of the letters, and he's better placed to guide the evidence-leading team. To that end, I think the right thing is to pause for 30 minutes. If you are still discussing within that 30 minutes, do send a message. Then we can grant you more time to confer with one another. Remember, we mentioned at Chambers the legislative imperatives to have this inquiry finished as soon as possible. We don't have time on our side. 12 months is going to expire very soon. And we cannot be seen to be arguing about these interlocutory issues when we are supposed to get to the heart of the matter. Because we are all here to investigate and bring all the facts. It's not about Advocate Batoyi he's not an accused, or he's not in a position of Advocate Chauke. He's just a witness. And if she thinks that she's been prejudiced, she knows what avenues are open to her. But let's proceed. As you go out to discuss, bearing in mind this legislative imperative, we cannot waste more time. In fact, we committed to the Minister that we may have to sit on Saturdays, given the list of witnesses that you people have given us. But if you are seen to be delaying the matter any further, it's going to be very difficult for us, because we have to prepare a report at the end of the inquiry, and we may not have sufficient time to do so. So I'm mentioning it to all of you, not necessarily to you, Advocate Ngoitobi, that let us work towards finality to enable us to discharge our task. We will adjourn until, I beg your pardon, yes, sir?
No, Madam Chair, I just wanted to ask how long, but I think you've answered that.
Take 30 minutes. We could use that to have tea if we've been supplied with tea. It appears that the ministry doesn't have money anymore to give us lunch. But we are told that we will be served with tea. Everybody here, the media, we are told that we'll only be given tea, all of us. But let's see what would have been offered. We should be thankful for what they are giving us. We all know that finances are tight everywhere. Let's go and have tea. We can reconvene at 12:10. If you still need more time, send our researchers and tell us how much more time you will need, then we will reconvene. Yes, thank you. We will adjourn for 30 minutes. Good afternoon, everyone. Advocate Gauteng.
Thank you, Madam Chair. We are grateful for the indulgence. We discussed the matter internally as well as in collaboration with the evidence leaders. Perhaps the best way is to allow the evidence leader to explain the position they finally settled on. Thank you, Madam Chair.
Thank you, Counsel. Advocate Kosana.
Thank you, Madam Chair. We, as evidence leaders, have considered this matter and decided, in view of the deliberations that have occurred today, to bring an application. And the application would be for the adjournment of these proceedings until, from what we have discussed so far, until Monday, the coming Monday. And of course, that application will contain the basis and the reasons why we're bringing that application. The time frames and the timetable for exchange of papers between the parties may be discussed, but we do need to bring that application. I may indicate at this stage that in broadly, the application will be on the basis of addressing the issue of the potential interest, and I emphasize the potential interest, conflict of interest, and in regard to Advocate Harley and the NPA team, legal team. And number two, the reasons will be relating to the list of witnesses that the evidence leaders has provided and the challenges that they've experienced in that regard. So they would, in broad, there'll be those two reasons in the application. There may be more, but those two will be there. I just wanted to give the panel an indication in broad terms what that application will be about. Yes, Madam Chair, I think I can stop at that point for now.
Thank you, Counsel. The first aspect of that application relates to a potential conflict of interest in relation to Advocate Harley, you said?
Yes.
And the application will be brought by who?
By the evidence leaders, Madam Chair.
The second aspect relates to, you said the second aspect relates to the witnesses.
Relates to the witnesses, the list of witnesses that was provided and the challenges that have been experienced so far by the evidence leaders.
All the witnesses that you have provided us with, you have challenges in relation to all of them or some of them?
Well, some of them, Madam Chair, yes. And we must indicate in particular in relation to this aspect relating to the Katomena unit and Major General Poison, and the like. That's all those witnesses so far. The Katomena unit, as well as Major General Poison, witnesses will be testifying in relation to that, in particular, that aspect. We have experienced difficulty and will explain in the affidavit that we intend to file the kind of difficulties and why we think it is necessary to complete that part of the case before going to the second aspect, which relates to the Mdluli case.
Just to clarify so that I understand, you said you have considered and decided to bring an application for these proceedings to be paused until Monday next week.
Yes.
So should I understand that what you are saying is we stop until next week Monday, or you bringing an application? When will you bring the application? It's a bit confusing for me.
Yes, thank you. I think you are correct that I didn't indicate exactly. I said the timeframes, of course, may be decided, of course, with the guideline of this panel, the timetable for the exchange of papers in that application and the hearing of that application for postponement, because we would like to bring it formally on paper.
Sorry? Meaning that while the exchange of papers is happening, the inquiry would have paused,
Indeed.
According to your suggestion.
Indeed so.
And of the witnesses that you have listed in relation to the Katomena case, who are not giving you challenges, aren't you in a position to at least consider calling any of those witnesses whose position is not challenging for you, so that we can make some progress?
As I'm aware, as far as I'm aware, and upon discussion with our team, we think we have a difficulty with all the witnesses relating to that aspect. That is now the Katomena and Major General Poison. Perhaps when I said some, Madam Chair was dividing between the one aspect and the other. The Mdluli matter, yes.
As regards the Katomena matter, all the witnesses listed by yourself as evidence leaders are giving you some challenges. I'm not sure what those challenges are, but you seem to be encountering challenges with them.
Yes, Madam Chair. I don't want to find myself perhaps, making a contradictory statement at this point. We will do our best to give as much detail as possible in the application, which will be brought. I believe there will be affidavits in that regard, and explain exactly what is happening, what kind of challenges we have experienced as evidence leaders.
Yes, I understand. The reason why I engage with you is to ascertain a possibility of us proceeding at least with any of the witnesses who may not be giving you challenges as far as the Katomena is concerned, so that at least we can tick off those witnesses, because we have a long list. And I'm not sure how we are going to proceed when we have expended closer to more than a month on one witness, and we are not even done with that witness. So assuming that you understand our predicament as a panel, and you as evidence leaders, because your role is very critical for our functioning. If you have any other witness, some of them you have consulted with. I remember at one stage, Advocate Mchweni was excused upon his request to go and consult with some witnesses, yourself too, counsel. And if any of those witnesses are ready, that's why I'm asking you questions. If any of those witnesses are ready and we can probably deal with their evidence to make some progress, shouldn't you consider, unless of course, as you say, seemingly, all those listed witnesses are presenting challenges to you? If that's the case, then maybe we should leave it there. And you'll explain to us in your application what the challenges are and why we cannot proceed.
Yes, Madam Chair, from our discussion as evidence leaders, we have a challenge with all the witnesses, and it's different kind of challenges. But we were able to conclude that at this stage, we are not in a position to call any of those witnesses. We appreciate the predicament and the time constraints.
I beg your pardon. If we are minded to consider this application or your request now favorably to postpone, have you considered the time frames within which certain steps will be taken by yourself and the other team, and then yourself in reply if need be, and the filing of written submissions?
Well, Madam Chair, we have not considered it with the Advocate Chauke's team. However, as evidence leaders, we did contemplate that we should have the application heard by this panel by latest Thursday or latest Friday this week, after the papers have been filed, including the submissions, if any, legal submissions.
No, I'm talking about time frames. With time period within which application should be lodged, if you were to give directions, ordinarily the parties should have agreed to that and present to us a consent document saying you will lodge your application on tomorrow afternoon, for argument's sake. They will file their reply, the answering affidavit by Wednesday afternoon. You'll consider your reply, if any, by Thursday. Written submissions may be filed simultaneously by the parties, something to that effect, to ripen the matter. That's what I'm asking.
Well, Madam Chair, we are prepared to do that. One, that has not been done formally. I think there were informal discussions, and I may be corrected by Advocate Nkabinde. There were some informal discussions around that, around the timetable when papers can be filed. But we did not, reduce that to writing. We, in any event, also wanted to hear what the panel's view is on that, and perhaps to get guidance, because whatever documents we will draft will have to receive the approval of the panel.
The Katomena witnesses who seem to be giving you challenges, if we were to say, let's leap into the next issue in relation to which the witnesses are not giving you problems, can't we do that? Is it possible? The Mdluli matter.
Well, I'll answer it from I haven't discussed that.
I think you can. I think you can confer with your colleagues. I don't want to take you by surprise. You can confer with your colleagues if you wish. Yes.
What I wanted to indicate, Madam Chair, is that also some of the developments with regard or the challenges that we've experienced are things that have arisen of late, as late as last week Friday and so on, and the panel will see that on our affidavits. But nonetheless, I can confer further on the question that is now on the table, what I've been asked.
No. You indicated earlier that as far as the witnesses are concerned, the challenges you have encountered are in relation to the Katomena matter. That begs the question as regards the Mdluli matter. If the Mdluli matter witnesses are available to be called, shouldn't that be considered?
I don't know whether I should start by code. I just want to, maybe I should confer with my colleagues here before I answer that question.
I think that's the right thing to do.
Thank you.
Council, if you need a bit of time to confer with one another, we can adjourn for a few minutes so that we can talk about this. It's critical. It's critical in the sense that we need to make progress here. And if we cannot make progress, at least we have to understand that it is something beyond our control, at least as a panel. But if the challenges are with the evidence leaders, it will be understood as such. So that's why it is important that you and your team should seriously consider what is possible in relation to calling other witnesses to make some progress. It cannot be seen to be, this matter was postponed for a month, almost a month in December. I don't want to go back there, but so much time has gone. We don't have much time now. And I really wish that all of us must work towards progress. So if it is possible, we should continue. If it is not possible, as you would tell us, you will let us know. That's why I would like you to have much time to consider all possibilities so that we can make progress. Do you need time to confer and discuss this matter in relation to the Mdluli matter, or you have finalized your discussion?
Sorry, yeah, we need time, Madam Chair. We'll request then a short adjournment just to finalize that aspect in our response to that.
Before we hear Advocate Nkabinde, my sister has a question.
Thank you, Chair. Advocate Skosana, the first reason why you are seeking an adjournment is for the panel to afford you the opportunity to bring an application to this panel which seeks to address the issue of the potential conflict of interest. Am I correct?
Yes, I said so, yes.
You said so, and that is the case.
Yes.
Right. Now, whatever the grounds that you may bring to the attention of the panel, maybe let me withdraw that question and ask this one first. When you make this application, specifically with the intention to bring the issue of conflict of interest to the panel, what is the ultimate goal? Is the ultimate goal intertwined with the question of funding legal representatives for Advocate Batui, or are they divorced from each other? Of importance to me is to just understand as to whether this issue of bringing the application to show us the conflict of interest, is it being brought with the ultimate view or ultimate intention of addressing the issue of funding Advocate Batui's personal legal representation, or what is the position?
Well, perhaps to say it is, maybe I didn't articulate it as I should. The issue that will require an opportunity to address the answer may be yes and no, because it involves, yes, it might involve the issue of funding, but essentially as to whether the NPA legal team is or will experience that conflict of interest. And it's not to tell the panel whether or not there's a conflict of interest. The question, the ultimate question, is of course whether Advocate Batoi can receive that legal advice.
I'm trying to ascertain as to what the first question is meant to address. So what you are saying is that that issue of conflict of interest, that application concerning the conflict of interest, is made to obtain what information whether Advocate Hali may consult or advise Advocate Batoi or not. Is that the aim? And correct me if I'm wrong, so that we save time.
Well, it's to establish whether there is, in fact, that's why we refer to it as potential conflict of interest, whether there is, in fact, conflict of interest. There may not be, in which event then Advocate Hali can consider to provide that legal counsel.
Okay. I'll ask again. Does it have to do anything to do with the funding of Advocate Batoi for her personal legal advice or not? Or is it not related at all?
Well, it's related to some extent and not related in others.
Much as I know you have not as yet put pen to paper, but I think it will help us just to understand as to whether information that you will be bringing to us as the panel when that application is launched, whether that information will be information that has already been shared with the Solicitor General and the Minister when the initial application and appeal were done, or is it information that is totally new? And let me inform you as to why I'm asking this. I wouldn't want us to get involved in a toing and froing with the minister and the state attorney and so forth. I just want to understand that. Is it something that is looking to also paving the way in the direction? Or is it something that has already been shared and we are now being brought into a better light of what is already known by the state attorney, the Department of Justice? Thank you.
Well, what I can say is that we as evidence leaders, are not privy to that information. We don't have that information. Our attorney is Mr. Sibele Meza, who is a different attorney from the attorney that briefs the NPA legal team. I think that information may well have been in their possession, but it's not in possession of our attorney, Mr. Sibele Meza. So we don't have information in that regard.
Advocate Skosana, that information I would have thought that during the discussions as teams now, when you make preparation or formulate intentions on what other avenue to pursue or not to pursue, you would have engaged even in the discussion. I think the chairperson did ask about whether you are privy to the information or not, and you did say that you were not privy to the information. There was a long break in between. And as you were sitting there as teams, either individually or collectively, certain thoughts came to mind about how to approach this. Did it not occur to you to try and get information so that we know that when we adjourn here, we are likely to be facing completely new information from the information that the department does have already, or whether it will be amplified information that has already been presented before the Department of Justice. Did you try to establish as to that case? Because remember that you argued for some time about this issue, about the interest of Advocate Batohi and so forth, and how the application failed at a initial level and up to appeals level. But then you don't know what had been said. Did it not perhaps cross your mind to try and source that information from even Advocate Sibele Meja?
Well, all I know is that Advocate Sibele Meja does not have. I tried to check that, and I established that it doesn't have that information. And the attorney for the NPA legal team is not here, and so far we could not get hold of him. I think one has to also consider that information might also be privileged information that cannot just be acquired as easy as that. Information, I guess you're asking me about in relation to what was the appeal to the minister and what was asked to the Solicitor General.
Yes, you do not know for sure whether the information is privileged or not. You say it may be privileged information. You have not established as to whether the information is privileged or not. Am I correct?
Yes.
You have not established.
Yeah.
So it may or it may not be privileged.
Yes.
Thank you.
As regards the two issues that you raised, the potential conflict of interest, you will seek a specific relief, I suppose, in relation to each one of them. Possible conflict of interest in your application because it's an issue. The second one, challenges as regards the witnesses, you will seek a specific relief in your notice of motion. As regards the first, if your information, I'm just thinking aloud, if the information you are going to establish is going to raise new facts that were not brought before the minister or even before the Solicitor General, are we the proper forum to consider whatever relief you'll be seeking before us? If totally new information which ordinarily ought to have been brought to the attention of the minister but was not, and it emerges now, are we the right forum, given that the decision in relation to the core issue is an executive, or rather entails an executive decision? Elaborate, Counsel. Because ultimately, you'll ask us to grant you some form of an order or a direction. But if the information you are going to gather appears to be an information that ought to have been presented to the minister when making a decision, are we the right forum to even be given that information to make what decision, if the decision falls within the prerogative of the executive?
Thank you, Madam Chair.
Oh, I beg your pardon. I will repeat myself very briefly. I beg your pardon, gentlemen. My question is, yes, Counsel. I'm trying to think aloud because you do not want to anticipate an application in respect of which an ineffective relief is going to be sought, whereupon we don't even have a power to grant that kind of a relief. So the long and short of this question is, if the information that is not before you, that you are going to establish, is the information that ought to have been presented to the Solicitor General in the first place, secondly to the Minister on appeal, is found, will we be the right forum to even consider that information, because the decision is that of an executive, the Minister herself?
Thank you, Madam Chair. I think the application that we are bringing is essentially to ask for an opportunity for that question to be considered, not for the panel to consider that information as such, which was brought before the Minister and so on. What at this stage, I think the application is to obtain permission from the panel to adjourn the proceedings until Monday, so that that issue can be resolved. And we think whether the information is already before the Minister or was not placed before the Minister will appear. One should remember that also the question of her getting legal counsel may get to a point where she has to obtain it privately, in other words, using her own, from her own pocket or from her own funds. We are saying, as evidence leaders, that opportunity that we are requesting should include that, considering all the questions. And when we return, it will be that she has obtained that legal advisor, whether from a private legal practitioner or from one that is funded by the state.
No, my question is different. My question is, pardon again, whatever you're going to establish counsel, you don't have information at the moment. But we know one of the issues relate to the potential conflict of interest, as you say, which impacts on the very request that was initially made to the Solicitor General and the Minister. Am I correct?
Issues were before the Solicitor and the Minister, yes.
No. My point is, and I'll repeat myself, the very issue that you have raised, the potential conflict of interest, impacts on the issue relating to Advocate Batoi's request to the Minister, ultimately.
Yes, Madam.
Is that correct?
It is correct, yes.
It is correct. Now, but the point I was raising with you, if it is correct, and this very information you are going to establish in due course was not brought before the Minister, are we the right forum even to know anything about that information in the first place? Because we don't have such a power which vests in the Minister to decide whether yes or no she could be afforded a legal representative. I'm looking at the question of relief, basically, that you can make an application, but when you make an application based on the facts that you are going to establish, if those facts are new facts and were not brought before the Minister, shouldn't you go back to the Minister and say, here are new facts that we didn't present to you, which may convince you as you exercise your executive decision to enable Advocate Batoyi to be legally represented at the personal level. Basically, this is what I'm saying. The panel doesn't have, you're not seized with such a power. Even if you come up with new information, to what extent does that information impact on the ministerial executive decision making?
Well, to answer the question, I think the panel doesn't need that power. And the panel is not asked to exercise that authority to decide whether Advocate Batoyi should be funded or not. The minister has already decided, as I understand it, the minister has already decided that she already has a legal team which is funded by the state, that's what the minister has decided. Now, the opportunity that we ask for is for the determination of whether there is a conflict of interest for that legal counsel to be provided by this legal team, the NPA legal team. And it may be that there is no conflict of interest. Then the NPA legal team will complete its task and grant and provide that legal counsel. If there is a conflict of interest, then the issue will have to be then resolved further, which I have already indicated may require that she now must obtain advice from a private legal firm.
So if I understand you correctly, and correct me if I'm wrong, what you want us, you seek to present to us is submissions or evidence to prove that there is a conflict. Do I understand you correctly, Counsel?
I'm not sure if I understand you, Madam Chair, yes.
The application that you The application you seek to launch deals in the first place with a potential conflict of interest. Now, if it is established from the facts that you are going to gather that there is indeed a conflict of interest, a matter which probably was not brought to the attention of the minister, shouldn't the matter then be taken to the minister, who has a decision, who has the power to make the decision regarding Advocate Batoyi's legal representation?
Well, Madam Chair, to decide whether, I'm not sure if the minister is to decide whether there's a conflict of interest or not.
No. If you present new evidence to her,
Yeah.
where in your letter or your memo you say to the minister, Minister, that which was presented to do previously, following on what information you're going to be given, did not encompass this information that shows or reveals a potential conflict of interest. We are therefore urging you to consider this new information that then impacts on your earlier decision when you reflect on the new evidence that proves a potential conflict of interest. Do you understand what I'm saying?
Yes. Yeah.
Therefore, if that can be the case, why is it that it is us who must make a decision on the conflict of interest? Because it's just a factual matter. It's either you establish a conflict and then you go back to the minister, and the minister decide on whether to reflect on her earlier decision. I think that's to start with the state attorney, Solicitor General. He may be persuaded. Then he can say to the minister, yes, I think Advocate Batoi deserves a legal team to represent her. The minister may also agree. My point is, why should such an application be brought to us?
Well, Madam Chair, let me start off by saying that may well be so, that an application may be brought before the Minister or the Solicitor General to say there are additional facts which establish a conflict of interest and therefore reconsider this application. But before we get to that point, first, we need to establish, or it must be established, that there is in fact a conflict of interest. Now, we haven't, in our submission, we haven't passed that point. We are asking for an opportunity to establish that, and that can only be established during the period that we are asking an adjournment for, whether there is a conflict of interest. And only after that can we go back to the minister, if that's the decision to be made, to say there are additional facts which establish that there's a conflict of interest in the team that you have directed must give advice.
Yes, I now understand. That's why we went this route of asking you questions, because you started at the application and we're talking about time frames as to when you're going to launch the application, when they are going to answer, when you're going to reply, when the written submissions are going to be filed. And we're talking in that context of you saying you seek an indulgence for a matter to be postponed so that you can make an application. And that's why these questions arise, Advocate Nkosana. But if you are saying now, it is not an indulgence to apply, but an indulgence to go and ascertain whether there is any information that may prove or disprove a potential conflict of interest with a view to approach the minister. It's a different matter. Am I right?
Yes.
But if the intention is to gather information to prove or disprove conflict of interest, why would you need 7 days to do that exercise? If I understand you correctly, to say you want the inquiry to pause until Monday next week. And I'm asking this question on the background that we are pressed for time. And we've had to write a letter to request an extension and give reasons for our request. But then we start on the very first day, we're talking about pausing for 7 days. Isn't that counterproductive?
Yeah, I understand, Madam Malloy, SC, from where you come from, but I think, I said earlier on we will reveal this in more detail, but perhaps in the interest, and I understand the time frames and the time constraints, we must understand also the changes that are happening within the office of the NDPP. And I think that actually in a matter of a week, I think there will be a new NDPP. One should remember that the decisions to be made on behalf of the NPA would normally involve the NDPP. I don't know if you, I hope we all follow with these many acronyms, but the decision has to be made by the NDPP. Now, the new NDPP will come in.
Which decision are you talking about now?
The decisions that
I
may...
beg your pardon. You say decision has to be made by the new NDPP. Which decision?
Well, when we speak about when we speak about the potential conflict of interest, we're speaking about the potential conflict between the NPA as an institution and Advocate Bato, who is currently the NDPP. So, and as an NDPP, she also makes decisions on behalf of the NPA. And we all know that in a matter of a few days, there will be a new person in that post. So
the postponement for a week will enable the new NDPP then to be seized with the matter, basically, because Advocate Batoi will not be there anymore by beginning of February, which is about next week.
Yes. Yeah, I think I've said much. The Advocate Batoi cannot be involved at this stage in that decision, which may have a conflict with her personal interest in the office of the NDPP. And at the same time, she is making decisions as the sitting NDPP on behalf of the NPA. So it's convoluted, but what we are trying to resolve are all those issues, and which we are just disclosing those in order to enlighten the panel on the issues that we have to deal with and that we're requiring an opportunity to resolve. That is not, we are mindful of the time that we have as an inquiry, but at the same time, those are serious issues that actually warrant proper consideration and may warrant the granting of this postponement. As we say, I'm merely elaborating and elucidating without paper at the moment. We will provide proper affidavit in that respect and also submissions.
It's a long answer to my simple question, Council. I was asking you, the postponement would enable the new NDPP to be seized with the matter. As you said, I mean, if you postpone for a week, that's the end of the period of Advocate Batoi. Then she cannot decide. Therefore, the new NDPP then will be seized with whatever decision-making power, including this very issue. Correct?
Yes, Madam Chair. Just that I elaborated, but yes, the answer is yes.
In fact, as you have said, and I hope I understood you correctly, we are not adjourning that you apply. If I understood your submissions, you are not going to apply. You are going to consider whether there is any evidence, new evidence, if I may say, concerning the potential conflict of interest that was not brought to the attention of the minister. Am I getting it right?
I'm not sure if it's correct,
yes,
Madam Chair.
You see, all these things that this question revolves around the issue of whether Advocate Batoi should be afforded legal representation, isn't it?
Yes.
So if the minister could have been given all the information that you're going to establish, maybe which was not before her, it means she must then be approached and say, reconsider your decision in light of this new information. Am I right in my understanding?
Yes, Madam Chair, I think partly because that decision would be to say, we're bringing this additional information, which was not before the minister, to say, now, grant permission that she be funded to employ another team other than the NPA legal team. Yet, at the same time, we are saying we still need to establish whether there is a conflict of interest. Otherwise, if there isn't, then the NPA legal team can continue to grant that advice.
Yes, that's what I'm saying.
Yes.
That's what I'm saying. I
Thank
just
you.
want to ascertain whether you are going to launch an application, an interlocutory application, or whether you need the time, a week, to go and consider all these things that you are raising. And if you find this information, then where to go to?
Well, Madam Chair, if we are able to secure that time, that opportunity, without bringing the application, a formal application, I think we'll all and subject to what Advocate Nwatoe may say, then we'll all be relieved from bringing that application and asking the panel to make a ruling on it. But Madam Chair, you have correctly, I think you've kept it so nicely and correctly that those are all the issues that, as evidence leaders, have taken into account, and which we thought we need to put it on affidavit formally in order to support this request for adjournment.
You see, Council, unfortunately, ordinarily, when you seek indulgence, a postponement, you apply. The reason why we ask you questions because you have not filed a proper application for a postponement for a week. And we need to understand why you are entitled to be granted that kind of a request. Because a postponement is not there for the taking. You have to explain to us, given the circumstances that we have elaborated on, the time frames and the time expended already, why is it that you should be given this, the request that you seek? Because we don't have anything in writing. So we have to ask you questions to determine whether indeed we can grant you the indulgence that you are seeking. So we are not just asking questions for the sake of asking. We want to understand where you are going to and what you seek to achieve.
Thank you, Madam Chair. I think I understand, and I have no difficulty in being asked as many questions as possible. I think I've been in that situation before, if not worse, in the past. So I think I understand perfectly. I have no difficulty being asked as many questions.
I am tempted to say, Council, lastly, before my sister asks, if we do not proceed with this matter, or as we are minded to do, we may grant you the indulgence. But the indulgence will be coming at the instance of the evidence-leading team, which will cause a delay. So the delay will be at your door as evidence leaders. Evidence leaders comprised of a team of 4 advocates. And we find ourselves where we are today. So I just want to place that on record, that the delay should not be placed at the door of the panel because we are all ready to proceed. And we are even trying to look at other avenues. Whilst the issue relating to Advocate Batoyi is being attended to, can't we even try, as evidence leaders, to look at the other possibilities of proceeding with other witnesses, the names of whom we have placed on the record? But we are engaging with one another, which something that is actually saying to us, to me at least, we are delaying with this process. I don't sit very comfortably with that kind of a position because time is not on our side. I'll repeat it again and again. We ought to have done better as an inquiry, as evidence-leading team, especially because you are 4 advocates. You have consulted with witnesses, and we're trying to really help you. Let's look at these avenues. Let's consider this. So you must also be seen to be helping us to make progress and not to delay the matter any further.
Thank you. Advocate Fosana, we engage you out of necessity. We fully appreciate that you sell time.
I understand,
Yes.
madam.
Yeah. Right, maybe let me just take off from where the chairperson has left the question, then I'll go to the next one. I would have preferred to do it the other way around, but that's fine. Now, my understanding of your statement when you are asking for a postponement, you say, is that what you are seeking to obtain is a determination whether there is a conflict of interest or not. Now, thus far it would appear that it would be 2 parties involved. It would be the evidence leader advancing whatever argument that has been brought to its attention, and then it would be Advocate Chauke's team also advancing whatever argument it may be. Now, what I first want to know is which side of this question are you? Is it about obtaining a determination that there is in fact conflict, and the other one is opposing that and wanting the panel to find that there is no conflict? Can you just indicate to this panel as to which side? Are you the applicant, or the evidence leaders team is the team that seeks to get a confirmation that indeed there's a conflict of interest, or is it a team that seeks to obtain a finding that says there's no conflict?
Well, the way I understand it is that we are on neither side. We are not on. Well, if there's a conflict, there is a conflict, and the conflict will be between the NPA and Advocate Batoyi. And if there is, then that means the legal team cannot advise her.
Thank you. You know, this question, it's a question that I'll say is just been changing colors and sizes and what have you, but it's the same question about the relief sought. Who is seeking which determination? And when you say, well, we are on neither side, what are you doing? Are you going to file, in the event that you come to a conclusion that there has to be an application, are you going to file an affidavit that says we shall abide by the decision? We not seeking any determination as evidence leaders now, because I think I got it wrong. As I was listening to you when you said, what we seek is to obtain is a determination whether there is a conflict of interest or not. Now, from that statement, what came to my mind is that here it means there'll be no less than 2 parties, one contesting for a determination that there is a conflict, and the other contesting against the determination. But I may have been presumptuous and assumed that that would be the case. And it would help us, you as the evidence leader, to just clarify that issue as to, you have made it clear that you are neither for nor against. So what role will you be playing as the legal representative leading the evidence leaders team in this respect?
Yeah, I think, Madam Ramakaka, we are correct that we are not on either side. All we are saying, we're asking that an opportunity be granted for that to happen. The legal team, the NPA legal team, will establish themselves whether there is a conflict of interest. If there is, then they cannot provide the advice. If there isn't, then they'll provide the advice, and the advice, we don't know what advice they will give. It will either, no, don't go back, don't, or it will say, and then we can then, from there, that Advocate Batoi, we are certain now she is not going to return to continue her testimony. And then in that event, what do the evidence leaders do?
Is there a role that you foresee playing? And when I say you, I'm talking about you as a collective. Is there a role that you foresee yourselves playing in this issue of a determination whether there is a conflict or not? And if there is a role that you see yourselves playing, what is that role? Thank you.
Yeah, at this stage, I don't think we really have a role there. The issue is between the NPA and Advocate Batoi as the current NTPP. So all we are waiting for will be an answer. Yes, there is a conflict, yes, or there isn't. And we think with all the information we have, the reasonable time will be up to Monday. And I've indicated that also there would have been a change of hands in the office.
Thank you. Let me then get off that subject. It has been canvassed. I can't say adequately. There may be a need to canvass it further. The question that now I want to go back to is the question of a list of witnesses. Remember, there are two grounds for the application. It's the witnesses' challenges and it's the potential conflict. Now, I'm addressing the issue of the list of witnesses, right?
Yeah, so sorry for interrupting you, madam. I just, that question, I think that's the one where you were saying you're going to grant me an opportunity to confer with my team. Unless it's not related to that, just wanted to.
Yes, I remember that I think it was actually the chair who then indicated that, you may get it, you may have to obtain instructions. And let me then be disciplined and restrain myself from asking you the question that I wanted to ask. I stop here for now. Thank you.
I'm going to make a follow-up on what my sister have asked you. You said you don't see, for now, you don't see yourself, the evidence leaders, playing a role in the issue of conflict of interest. This is between the NPA and Advocate Batoi. Now, are you requesting this period of until Monday on behalf of the NPA and Advocate Batoi? Or you made your own judgment to say we will need this period, or they will need this period to deal with the issue?
Well, as evidence leaders, it has been repeatedly said that our duty is to bring evidence before this inquiry. And we have been doing that. Advocate Batoyi has been called as a witness by the evidence leaders. And in the process, there were these challenges or difficulties. So we're trying to merely resolve that. And we thought in our own right as evidence leaders, we could bring that application in order to ensure that things proceed in a proper manner. And she is given that opportunity. And we think a reasonable time would be up to Monday, in view of what I've mentioned, what is happening at the moment.
So as a follow-up, it is the evidence leaders who determined this period. And while keeping in mind that you are not going to play any role in the resolution of the whole issue. And you are right. You, as evidence leaders, you are the ones who are driving this process, who must see to it that it comes to an end. And after having raised issues about timeframes and everything, and after you having considered that you are not going to take part or to play a role in this issue, do you still insist that you need 7 days to resolve the issue of conflict that is between Advocate Batoyi and the NPA? And I will add further, because you now brought in the issue that in next week a new head of office will be taking over. Now we're breaking until Monday. Come Monday, a new head of office is taking over, and I'm wondering if the new head of office would have considered everything and made themselves au fait with this whole inquiry and its issues by Monday, or for the head of office to take a decision whether there is further funding for Advocate Batoyi, or Advocate Batoyi must get her own private legal funding. It seems like we are trying to kick the can down the line. I don't see the end of this, because come Monday, there will be another issue. There is a new head of office who needs to apply their mind in order to take a decision. I don't expect a person to jump into the office on Monday and decide, okay, no, we are not funding, or no, we are funding. They'll have to weigh the options and to consider that there is an NPA team, and where is the conflict, and what is happening, what has been happening during the initial consultation stages, and all those. And also maybe want to go through the whole record to acclimatize themselves with what is happening. So is this ever going to come to an end? And also, what informed you to request for 7 days? I don't even want to imagine what will happen beyond the 7 days come the new head of office next week. Why? What? Because Advocate Batoyi started the process, and rightfully so. She was empowered. She is empowered, actually, not in the past tense. She is still empowered by a statute to deal with this process. So why should it be that we want to postpone, we want to pause until a new head of office comes in, and then deal with the issues thereafter, when we have a process that has started, lawfully so and legally so? I don't want to believe that we are trying to kick the can down the line, down the road. Thank you.
Well, certainly not from our side as evidence leaders. We're not trying to kick the can down the road. one must consider that when you say there is a conflict between the NPA and Advocate Batoyi, who do you ask that question? On behalf of the NPA, you have Advocate Batoyi, because there has to be a person. NPA is an institution. Now, obviously, you cannot ask that question to Advocate Batoyi to give you an answer on behalf of the NPA. And that's in that context that we are saying it is important, and perhaps it may help us to resolve the issue if the new person takes over the office and makes the decision on behalf of the NPA. And may I add also that we have been doing some of the things, and some of the submissions also have been discussed with the NPA legal team, who at this stage, of course, they have no audience in this inquiry. I don't know if the panel still intends to grant them an opportunity to address them, but we also had some discussion with the NPA legal team.
As a follow-up, Chair, Advocate Skhosana, shouldn't right from the beginning, your submission, shouldn't it have said we want to pause and wait until the new head of office comes in order for the head of office to take a decision? Because we've heard that you want to bring an application to this panel to make a determination. The next thing, if there is new evidence, it needs to go to the minister. And then the third thing, you are not going to play any role. You don't see yourself playing a role. But all I'm saying is, it seems like the crux of this request for a postponement is to allow the new head of office to come in and deal with this issue. Am I correct? Correct me if I'm wrong.
Well, it's an important factor, but it's not the only factor. We have, and we intended to put that on paper. There are several reasons which I've divided into two categories, but it's not the only point. It is an important point.
The answers are giving rise to further questions, Advocate Skhosana. I thought that a process has started, in respect of which Advocate Batoyi approached the Solicitor General and then the Minister. I don't see why the new NDPP comes into the picture. If the information to be established as regards the potential conflict of interest is found, the new NDPP doesn't come into the picture. He doesn't have powers to make any decision whether Advocate Batoyi should be given money or not. The matter goes back the same route where it started, back to the Solicitor General with the new evidence, and then the Minister on appeal. So I don't think we should complicate issues here and bring a new NDPP into the picture, because that's going to create a whole problems for us. And I'm just saying there's a matter of guidance. My understanding is that this decision taken by the Solicitor General and then subsequently the Minister, which does not favor Advocate Batoyi, may have to be revisited because of this alleged potential conflict of interest. And if indeed, as you receive the information, you find that there is a conflict of interest, then you present it to the Minister, first to the Solicitor General, who may just resolve this issue and say, yes, upon consideration of this new issue, we decide otherwise. If they don't, at the State Attorney, you then approach the Minister with this new information. I don't see how the new NDPP comes into the picture. Where do we start? Where do we end with this whole thing? So I'm raising it so that we don't lose sight of the fact that a process has started, and we may have to go back to that same process without necessarily involving the new NDPP, because the decision is that of the Solicitor General and the Minister, as I understand it. So I thought that you need this postponement to consider that. You said that you are not making an application. So if you need time to go and make that determination, shouldn't 2 days be enough for you to ascertain that the Solicitor General is here? Then you can then decide what procedural steps as regard the decision you seek finally are going to be. Do you really need a whole week to do that? And that's the point my sister was raising. Why do we need a week? Because if you had applied, we will be having facts in front of us. That's why we are asking this question. Why do you need a week? A full week, for that matter.
Well, Madam Chair, it's because of the reasons and the other grounds that we put forward, and we seek to put forward in that application. We have mentioned, and I said it's two categories. It's about the issue of the conflict or potential conflict of interest. There's also the issue of witnesses, which we also seek an opportunity to explain by way of affidavit. And the question that has been raised about the other set of witnesses relating to the Mdluli case, I will need an opportunity there to confer before I respond to that.
Yes. The question of witnesses, we had indicated that we'll give you time to confer with your colleagues, because if we are agreed that the process to follow, if you're mandated to grant you the 7 days, or maybe even less than 7 days, is to make a determination on evidence as regard to potential conflict of interest. Then the other issue as regard the witnesses, we said, if it is possible then to proceed with the Mdluli matter, then consult with or confer with your colleagues and determine whether the witnesses who have been lined up can be called. Then we can proceed. Whilst we are dealing with the Katomena issue, the potential conflict, the witnesses that are giving you challenges. So I suppose we go back where we were, that we will afford you an opportunity to then confer with your colleagues to discuss that second matter. Can't we proceed with the Mdluli matter? Those witnesses would have been lined up. You'll have a time, I beg your pardon, I'm talking?
I beg your pardon, Madam Chair, just a paper that I wanted to understand.
You'll have regard to your paper. I'm saying, I'm just trying to line up the process. If you are agreed, then we can pause, and then you properly consult with your colleagues as regard the second issue, and so far as the Mdluli matter is concerned. Maybe we can start whilst you are dealing with the other issues.
We will respond to that. And Madam Chair, while you're on it, the note I've received is a request that Advocate Batoi be excused for the day. That's what disturbed me a few minutes ago.
Thank you, Chair.
Yeah, before you proceed, Advocate Batoi has just asked that she be excused. I think we can allow that. We are engaging with one another here, so Advocate Batoi can be excused. Is it cousin?
Yes, but we have to agree about who will inform her about the next date. Because now she cannot
Yes.
Yes.
My sister raises a point someone will have to tell her, if you decide that we'll postpone this matter for a week or for less than a week, someone has to give her a date. I suppose yourself, as the evidence leader, you brought her here. I think it would be proper to hear from you. So I don't foresee any difficulties with you conveying to Advocate Batoi about our final decision in relation to the postponement.
Yes, we'll do so, Madam Chair.
In that event, Advocate Batoi, we have received your request. You are excused for now. Thank you.
Advocate Skosana, I'm asking for a question. I'm asking a question which is capable of being asked in or answered in clear and unequivocal terms. And if it means you get information from your instructing attorney, you can do so. And understand one thing, I will not try to even tempt you or provoke you to come up with the information that was placed before the minister. I'm not looking for the substance of the information when the application was done. All I am asking for is for you, if by now you still do not know, for you to find out from your instructing attorney as to whether the question of potential conflict interest ever served before the SG, I want to call it in full. That SG, what do you call? Solicitor General. Thank you, senior citizens on the bench. Solicitor General, or even the minister. Just to establish that from him as your attorney of record. So you understand when I say it's simple and capable of a clear and unequivocal answer. Because it's either it's going to be yes, it had been placed, or no, it wasn't placed. The issue of potential conflict of interest when Advocate Batoi applied for funding from the department.
Yes, I will ascertain that.
Thank you, Advocate. Are you done? Hello?
Yes, I'm done. Thank you, Chair.
Thank you. Thank you, Reskosana. Advocate Toby.
Madam Chair, we will oppose the application for postponement, but we do not think that we can oppose the fact that they want to apply. So we think they should be given a chance to apply, but we will oppose it on the merits. There is a lot to be said, but I think it should wait until we see the content of the application. If they want to bring the application for consideration this week, we would propose that they try and launch it by tomorrow at 5 p.m. and give us a chance to answer it by Wednesday at 5 p.m. It can be set down for argument on Thursday at 9, and they can file a reply at the same time as the matter is argued. And that will give the panel the Friday to make a determination on whether the postponement is granted or not. Now, arguably, Madam Chair, it can be asked, well, what's the point of this exercise, because they only want an adjournment until Monday. But we think it's nevertheless important to put it on oath what the problem is, why the matter cannot proceed, bearing in mind the public interest that underpins these proceedings. It's the first time we've heard that there are problems with witnesses, but I also don't want to speak about that because my learned friend has not explained the nature of those problems, and maybe he is waiting until someone qualified goes under oath on those. But we will see what they say in those. The question about Advocate Batohi, I think I would just want to say maybe two things. One is that we must not forget that she has walked out of the proceedings without the consent of the panel. The panel should not create the impression that you can reward the delinquent behavior of a witness who walks out and then makes an application while outside. She walked out on the 15th of December. Today she was present, but even today she elected not to give evidence. In both of those instances, those were unilateral decisions which did not have the permission of the panel. So although we are debating the question of her access to legal representation, the context must not be forgotten that we are dealing with a witness who's taken the law into her own hands and disregarded the authority of the panel. That's the first contextual matter that is really critical there. The second issue around the unilateral action of Advocate Batohi is the impact that it has on my client. My client is on suspension. He believes that his suspension is wrongful because he believes that the charges are without any foundation. Whether he's right or not, he is entitled to a speedy determination of that question. The election of Advocate Batohi to unilaterally abscond from the proceedings has already taken a month and a week from these proceedings. So that is why we will be opposing the request for the adjournment. If our learned friends are ready on Monday to call the next witness, we would of course be pleased and we will be ready to cross-examine them as soon as possible. But I understand that that question also depends on the challenges they will be outlining on paper. And that's why it's premature to make commentary on that issue. So in summary, Madam Chair, we are not standing on the way. We will play along and cooperate. And we've got a proposal around the timetable. Thank you.
Yes, thank you, Advocate Nkabinde. But you have to remember that Advocate Nkosana seemed to have changed tack. Initially, he sought an adjournment so that they could apply a substantive application. Subsequently, he says what they need is time to go and consult and make a determination whether there is a conflict, meaning he's doing away with an application, and once they find that there's a conflict, then they will take the next step. That's why the engagement as to then who is the right decision maker if they find that there is a conflict. What is the impact of that finding or determination as they will find when they assess their facts or evidence? And I said to him, this is not a forum to make a decision eventually. It's an executive decision. And I would like to hear from you. The process kick-started with the Solicitor General. It ended with the Minister on Appeal. Now, if they have to start the process de novo on the basis that new evidence has surfaced which impacts on that very decision. They must go the same route. And the point we make now is the same route, is that determination, establishing those facts, require a week. We at the moment, tentatively, we think a week is too long. They are not bringing an application, if my understanding is correct. Because if they bring an application, the question is, what relief? And I'll be very much interested on the relief they seek from us. If you don't have the power to decide on whether Advocate Batoyi should be given funding or a separate legal representative or not. It's an executive decision, not the decision of the panel. That's why they have to go back the same route. But do they need a week to do that? That's the question.
Madam Chair, the answer is no, they don't need a week to do that. They need a day. There are substantive answers to it. Advocate Batoyi is not entitled to state funding. State funding is discretionary. She has no right to state funding. The panel has no power to order the minister to give Advocate Batoyi her own funding. Advocate Batoyi is also not entitled to consult with an advocate in the middle of her cross-examination. That is in violation of the rules of the bar. So the relief that she wants is against the law of this country. But it's premature to engage in that argument until we see the application that will be brought. The second...
No application. You won't see any application.
Well, unless I misunderstood my learned friend, I thought they will still bring an application because he says it's two-pronged. One, the first prong is the conflict issue. The second prong is the witness readiness issue. So an application is coming, as I understand. But insofar as the first prong to the issue, she has absolutely no right to any of the things she's asking for. Now, you cannot ask a postponement of an inquiry in order to achieve things you are not entitled to by law. So, but they still want an adjournment so that they can work through the difficulties they are experiencing with witnesses, something I sympathize with until I see what exactly the challenges are. But at the moment, I don't know, and maybe my learned friend also doesn't know, and we will see what they say. So it's only in that context that I say a timetable is still indicated, because we may have to deal with the problem that if you were to say to them, now, Madam Chair, it's 2:15, call your next witness, they won't be able to call anyone. And so that's why they want a postponement in order to sort out that problem, which I understand, and that's the timetable I was really addressing myself towards. If he doesn't want to bring an application in relation to the first issue, that's fine, but I understand him to still persist with it if I'm fair to his submission.
Yes, thank you. And in fairness to the evidence-leading team, we have given them a leeway to confer as regards the issue of witnesses, which would ordinarily have necessitated that application, as you say. So we will have to await their conference. We'll adjourn and enable them to talk, to establish whether we can start with any of the witnesses in relation to the Mdluli matter, at least, so that we don't waste time. Whilst the issue regarding the potential conflict of interest is being considered by them without bringing an application. And of course, that issue, if it is so well established, you then land on the desk of the Solicitor General and then the Minister. It has got nothing to do with this inquiry. And if the Minister is persuaded, then she will decide as persuaded. Or if the Solicitor General decides favorably, he will decide. These are public funds. We don't get involved there. If the Minister and the Solicitor General has money to engage further counsel, further set of advocate because of the alleged conflict of interest. That's their decision. But what bears heavily on us is the delay. We should be able to proceed, at least with some of the witnesses. Do you agree?
We agree entirely. There's something to be said about the delay. It's important to get moving with the inquiry. Advocate Chauke is also entitled to know the outcome. But this is a case also of immense public importance. I don't know of any inquiry like this where the question of a prosecutor not prosecuting despite the evidence and prosecuting without evidence has ever been tested in this country. And the accusation is made by a person no less than the NDPP. And it is made against a DPP. So this is a matter of immense importance. And the facts that have been uncovered so far are also troubling facts. So the public is also entitled to an outcome. I always think, Madam Chair, since the evidence in this case of the mother of KwaZindlovu, she is entitled to know what is the truth about the killing of her son. And the delays are not helping her to get resolution to what happened to her son.
Without elaborating much on the issue of public interest, it's also a matter of legality when there's no finality to issues of such national importance. Put aside the issues of budget. A lot of money is expended on this inquiry, and it has to be brought to an end as soon as possible. So there's just so much at stake. It cannot just be issues of postponing for the sake of postponing. That's why we're engaging with counsel, to understand why is it that this matter has to be postponed further. It was postponed last year. We lost more than a month. Now we're going to lose a week. That's why we're engaging with counsel to understand the basis for postponing for a week. If we can indulge them, because I think in fairness to them, they need to confer with the Solicitor General, Advocate Andrew Chauke. I've seen your correspondence. They must consult with you, sir. But a week is too much. We need to finalize this matter, at least make some progress. So I think, Advocate Ndagaitobi, we will take an adjournment, unless my sisters would like to ask something. We will adjourn for, how long would we need, Advocate Nkosana? What do you, 15 minutes? 15 minutes or so? And you will let us know once you have discussed. You know what our position is. I think we have repeated ourselves again and again. And please, when you come back to us, assist us, because we don't see ourselves going home to wait for next Monday with an application just for you to go and talk. So, Advocate Nkabinde, thank you. I think, in fairness, we will, after my sister has asked, and if there's any further question from my sister on the left, we will then adjourn for 15 minutes to enable Advocate Nkosana and team to talk. And when you are ready, we will come back. You will then have to indicate whether, in the context of the issues of Mdluli matter, whether we can start either on Wednesday to notify the witness who will come, and we continue. So don't let us know. Yes.
I just wanted to ask you to consider this. Remember, we adjourned on the 15th of December, and on the day of the adjournment, we knew that Advocate Batohi is going to request her own personal representation. So that's one thing that you need to consider, and also consider when did the minister take the final decision and what happened thereafter. And also the fact that you had a framework, you had an inclination of the witnesses that you're going to call. And I don't want to believe that they all dropped you on Friday, this past Friday. So while you are conferring, please try to give us as much information as you can so that we understand what happened. I don't think they had a meeting on Friday and decided, oh, the inquiry is sitting on Monday, we are all not going. So please take us along on this a month and a week that we've been waiting, and while time is ticking. What happened in the process, and what steps did you take to try and mitigate, to try and assist this inquiry to be finalized within the set time frames? Thank you. Thank you, Chair.
Hosanna, I see you're pressing. Yes.
No, I just wanted to confirm that we will do our best to bring that information.
Thank you, sir. Council will take an adjournment for 15 minutes until 3:15, is it? Until 3 o'clock. You will send our researcher to call us. Thank you. Good afternoon, everyone. Good afternoon, Council. Advocate Skosana.
Thank you, Madam Chair, and the panel for giving us an opportunity to confer. Madam Chair, before addressing the issue, and I believe I'm going to be short on the issue of the witnesses, it has been indicated to me that Advocate Harley, SC, would like to address the panel as well, particularly on the issue of the conflict of interest, insofar as the resolution of that question may require up to a week, up to Monday next week. I will leave that to the panel, that issue. But on the question of witnesses, Madam Chair, the answer is simply that as evidence leaders, we had a plan. And firstly, the plan was that we were going to deal with the issue of the Katomena and the witnesses. And on that basis, I personally requested to be excused from this inquiry, to go and consult with some of those witnesses. And I consulted with one of them. One must remember that these witnesses are of high-ranking officials, advocates, most of them. One of them I consulted for not less than 12 hours. And thereafter, that was now before the adjournment on the 15th of December.
Sorry, Council, the witness you consulted with, was it in relation to Katomena or the matter?
The Katomena, Madam Chair, yes. And our plan was that we wouldn't like to deal with witnesses haphazardly. Call a witnesses in relation to Katomena and then the next in relation to the Mtuli case. But then I consulted with that first witness, and thereafter, on the basis of what I had been told, prepared a statement, which was not a short statement, of at least 20 pages, and provided to the witness, who then informed me that it's going through the statement, and we're now in the thick of the festive season. And later on, I also consulted another witness who had been allocated to me to deal with that witness. Second witness, who we could not physically meet over the festive season, but I held a consultation over certain aspects with him, with the understanding that we'll continue with the consultation in the beginning of 2026. Now, the first witness that I consulted with, after a while, I think it was about over 2 weeks, returned to me to say he's not happy with the statement, and she requires an opportunity to prepare her own statement. That being the case, and
she needed an opportunity to
prepare a statement of her own. Yes, and provide it to me to be able to settle it, and then we could finalize our consultation. Also, one must remember that we needed to provide statements to the team of Advocate Chauke.
And these witnesses, as you said, are high-profile witnesses?
Yeah, witnesses, yeah. They are advocates in the NPP's office.
Yes.
Yes.
So she is an advocate. She could prepare her own statement.
She could prepare her own statement, and which days passed, and I made follow-ups as much as I could. Where is your statement? is not coming through, it's not coming forth, that and I'm giving just a broad overview of what happened. That was now up to last week. It was only on Thursday, to our greatest surprise, that the witness informed me that she is not prepared anymore to testify. And she gave us the reasons for doing so. She gave us a statement, quite a long statement for us to go through, some report that she had previously prepared for the office of the NDPP. Now, that was now Thursday last week. And on Friday, I also received a WhatsApp message from the second witness, who informed me again that because of his commitments, in short, because of his commitments, or the commitments that he has made this year in his life, the studies, and he counted a number of things, is no longer prepared to testify in this inquiry. And which we conveyed, I conveyed to the team. So, in essence, our plan, and these two witnesses, I must mention that in terms of our estimation, the first witness would have taken our estimation about 8 to 10 days. The second one, 6 to 7 days. And we had contemplated that in the event Advocate Batoi does not return, we would be able to cover that period. And the rest of the colleagues, during their testimony, the testimony of these witnesses, they would be going out, they would be excused, just like it happened to me, to go out and consult with these other witnesses so that the proceedings are not interrupted. We can proceed with the case. I also want to mention that Advocate Motlabunyane SC, on the other hand, was also consulting with a different witness who also would, according to our estimation, would take about 10 days to 15 days. That's our estimation of the testimony. And received a message from his attorneys that the witness will not be able to testify.
His attorneys, are you referring to Advocate Mhlamunyane? His attorneys.
Sorry, the attorneys of the witness, who has separate attorneys. So we were informed that they need to consult with this witness, prepare the witness, and in what they are doing, the witness will only be available to testify towards the end of February 2026, in this inquiry, because they want to make sure that they secure the rights of their client, who
If
is
I
the
may
witness.
ask, is that Major General Boyson? Because I saw a letter from an attorney which expressed sentiments to that effect. Is that the Attorney Kun? Is that attorney?
Madam Chair, Madam Chair, you are right on the point. Yes.
Well, that takes us to the third witness. You've spoken about two witnesses.
To
This
the
one
third witness,
is the
yeah.
third witness.
I am informed that the witnesses, and that would take about 2 more, well, I think 3, in the Katomena one, who my colleagues, we allocated each other, one another. They had difficulty getting hold of the witnesses in the first place during the festive season, some of whom were not prepared to meet them during the festive season.
Are you speaking for or on behalf of Advocate Chauke, for instance? I remember at one stage last year, he asked that he be excused to go and consult. Are you speaking on his behalf as regards when you say my other colleagues?
I'm speaking on behalf of Advocate Chauke and Advocate what's his name? Sorry, Madam Chair. I'm used to the first name.
First hear what the position is with regard to Advocate Chauke, because I remember he had to be excused last year to go and consult with the witness, and what has happened with regard to that consultation. I just want to establish whether the evidence leading team has prepared witnesses for us to proceed. And if there are challenges, precisely what are those challenges?
Yes. Madam Chair, maybe to also add or to clarify is that as far as the witnesses relating to the Mdluli case, must be honest that we had not consulted. And the plan of the evidence leaders was that that would take place once we see we are towards the end of the case relating to the cattle manor. And would like to also emphasize that what has really disturbed us and put our plan off track is what happened last week, because with the two witnesses. Because had that not happened, we are sure that we would be able to proceed, even if in the light of this postponement that we're asking for with those two witnesses, and they would take a time long enough for the other issues to be resolved that we are dealing with regarding Advocate Batoyi.
But let's get to the specifics. How many witnesses did you list in the list were to testify in relation to the cattle manor matter? Because you have spoken to two witnesses who collapsed that you had consulted with, and the third witness who is supposedly collapsing is Advocate Boyson. We have seen the correspondence.
Yes.
There are other witnesses in your list as regards the cattle manor matter. What is the position in relation to those witnesses? You mentioned that your colleagues have not been able to consult. In relation to which witnesses were they not able to consult? Pardon, yes, sir. I'm sorry. In relation to which witnesses have your colleagues not been able to consult?
Madam Chair,
in relation to the cattle manor matter?
The cattle manor matter, because we had resolved and planned that we'll deal with those witnesses and be able to conclude that. And the consultation in relation to the Mdluli case would take place when we see that we have covered the cattle manor, and towards the end of it, of course, we would ask for an excuse of some of the colleagues to go and consult so that there is no interruption. But
How many witnesses were allocated to each one of you?
I personally had at least three. Yeah, but I must indicate that for this period, I was focusing on the witnesses that I was going to call.
So you
And-
consulted only with 2 witnesses who have collapsed?
We have collapsed, yes.
The third
as
one?
Of last week. The third one I had not consulted with. I had not even had an opportunity to do so because my focus was on the 2 witnesses. And one would appreciate that the issues of and information on this matter is quite involved, and my focus was on them. I have not yet consulted with the 3rd witness.
Advocate Mchweni, how many witnesses?
2 in the case.
Thank you, Madam Chair. Chair, according to the record, to the allocation, it was 2 witnesses.
And what has happened with your role?
No, in fact, it's 3, Madam Chair. I apologize, it's 3.
Witnesses?
Yes.
How many have you consulted with? How many have you consulted with?
Chair, I'm going to be honest, I've not consulted with either of them because the idea was that we would, once we resume, the idea was I would have been excused to consult with them so that we can prepare the statements. Their evidence is not long, so I anticipated that within a week or
Please
2.
speak to the microphone.
I had not consulted with either of them at this stage because the idea was us to, we're still familiarizing ourselves because, like, for example, there's an officer here whose evidence is interlinked with both the Cato matter and the Mdluli matter. And due to the voluminous nature of the papers, one had to start familiarizing themselves with myself with the Cato matter, then used the festive season to familiarize myself with the Mdluli matter. Then the idea was, once the hearing resumes, I would then ask to be excused so that I can go and consult with them, prepare the statements. And the anticipation was that it would not have taken me more than 2 weeks to finalize their statements. So hence, I had not consulted with them. But the idea was that I was not going to sit here throughout the evidence of Ms. Patoy or these other witnesses.
Last year, you asked to be excused to consult with some witness, if my recollection is correct.
Yes, at that stage, the idea was between Advocate Kosana and I, was that we would share the 2 witnesses, Advocate Noko and Mlojo. But because Chair refused that I should be excused, then hence Advocate Kosana had to also consult with Advocate Noko and Advocate Mlojo. But the idea was that we were going to share the 2 witnesses together.
If my understanding is correct, on the division of labor, not much has been achieved by the evidence leading team. And I'm saying this with the greatest of respect, but look, we are now on the 4th month, or if I may say, the 3rd month or the 2nd month. And we are still talking in terms of we have not consulted with witnesses.
Chair, unfortunately, but what one can't lose sight of the fact is the stage at which we came into the matter.
I beg your pardon, sir?
I'm saying, in as much as that is correct, sight should not be lost of the stage at which we came into the matter. We came into the matter when the hearing had resumed, and we were expected to, amongst others, familiarize ourselves with the papers, also be here to assist the evidence leader during the leading of the evidence. So the only time that we had so that we can focus and delve into the papers was over the festive season, because the last 2 weeks, the 2 weeks that we came into the matter, we had to be here, and at the same time use the after hours to read through the papers.
Now, of the 3 witnesses, who could be ready to start in due course? Have you started? Maybe it's a fair question. Have you started?
Chair, no, not yet, but I can start immediately, and depending on the availability, I can try and be ready within a week.
I'm not trying to dictate how you should run your side of the matter.
I appreciate that, Chair, but
But,
at the end of the day, I have a role to play here, and if that role means that I have to be dictated to, I would welcome the dictation.
I can't dictate to you. You are here to gather evidence and present it to us.
Yes, that's
We
what
don't
I'm
even
saying.
know who are your witnesses are. You've just given us a list in December. And you expect that you would have gone out of your way to try to ripen this hearing.
I appreciate that, Chair, but hence I do not want to be seen to be giving excuses. But also, Chair, one has to appreciate that it was festive season. Some of these witnesses had their holidays planned. And one couldn't just give them a call over Christmas holidays and say, hi, can you avail yourself for a consultation? One had to respect that as well.
Yes.
Yes. So had it not been, but if it did not have a festive holidays in between, the criticism would be justified under the circumstances, Chair.
Are you saying the criticism is not justified?
Not necessarily, Madam. I'm just saying that maybe. Okay, of course, I'm lost for words.
It is not even a criticism. It's a fair statement
Yes.
from the bench.
Which I appreciate.
I think you must withdraw that.
I withdraw the statements and criticism, unreservedly so.
Yes, thank you. Yes, thank you, Ramchani. And the junior counsel, were you allocated witnesses to consult with?
Yes, Chair, I was allocated 2 witnesses in the Mduli case, and 2 weeks ago. And I also must say that because I came at a very late stage just before the adjournment, I had to go through the record and familiarize myself with it. And I used the December holidays to do just that. And because we are still going according to the plan that we had, I did not foresee that it would collapse completely within 2 days. So I have not consulted with them, but I'm going out to do that.
You see, I'm asking all these questions, counsel, to make sure that eventually, if we are to say a postponement is warranted, we know on what basis we are granting you the indulgence and for how long.
Yes, Chair.
Because, as I mentioned to senior counsel earlier, as you know, postponement is not there for the taking. It's an indulgence.
Correct, Chair.
And we don't have an application in front of us that will inform us as to whether the request should be granted or not. And am I correct that the witnesses that have been allocated to you also relate to the Katomela case,
No, Chair, it's the Mduli case.
the Mduli matter?
Yes.
Have you started? You haven't started at all.
Consulting with the witnesses,
Consulting.
no, I have not.
When do you plan to start that consultation?
I will have to contact the witnesses as soon as we adjourn, and then I'll just take it from there, Chair.
Thank you, my sister.
If I may ask, was there any particular reason why you decided to concentrate only on the Katomela witnesses without taking statements from the Mdluli witnesses? Not with the aim of calling a witness in the Katomela and then calling a witness in the Mdluli matter and then confusing the record. But I'd like to know if there was any specific reason why you decided to treat them as 2 separate matters to a point that you want to finalize only, you want to consult these witnesses on first before you go to the other witnesses.
I am not sure whether there's really any particular reason, but I may say that, look, having joined these proceedings also in the middle, I found the evidence being led already of Advocate Batoyi, and looking at how things were, is that the focus was mainly on the Katomena. Of course, her evidence covered, to some extent, the Mdluli matter, but it seems to us, and when we discussed it, that it would be proper and logical to deal with that part of the case and complete it, and then focus on the other part of the case. I must mention also that with Advocate Chauke was given those witnesses for Mdluli, particularly because we needed to give an opportunity to familiarize herself with the information and the facts of the matter. And that would have given an opportunity to do that if things were to happen in the normal way. But firstly is that we understand and we all didn't know what is going to happen now that Advocate Batoyi took the decision in December. Number one. Number two, our plan was that we are going to fill that gap so that there's no interruption through these witnesses. That's why my absolute focus, and those witnesses would have, if they were prepared to testify, covered quite a great area of the case, evidence of the case. So we in all reasonableness that we had, we thought that would secure and avoid interrupting these proceedings if we were to secure these witnesses. And all indications from them, and I speak personally because I spoke to them, were that they were more than willing to testify. And they gave me some statement, and as I indicated, I consulted for many hours with one of them. And it was really a sudden and unexpected turn of event when they said they're no longer prepared to testify. To some extent, and I'm not saying perhaps to some extent we are to blame, but essentially what has happened is what we really could not reasonably anticipate or expect to happen, particularly in regard to these two witnesses.
It is, however, correct that when you were appointed, I think Advocate Skosana, Advocate Muchwene first before you, I think Advocate Muchwene was appointed before you, correct?
Yes.
And subsequently after you, the junior counsel was appointed. When you were appointed at that time, Advocate Batoyi's statement, or a statement under oath, was before you, as it was before us. And that statement encompasses both issues, the Katomena issues and the Mdluli matter, which in my view, and correct me if I'm incorrect, would have given you a start, all of you, those who are allocated to consult, at least to start with some witnesses, junior counsel, especially with relation to the Mdluli matter there. Because the statement was there, the affidavit was there. It is not like everything that surfaced during cross-examination was mentioned for the first time. There were other issues that she raised in her statement which would have enabled you to identify the relevant witnesses. So why is it that that was not done? Just to expedite the matter. I'm trying to understand. Fine, the 2 or 3 witnesses have collapsed, but for the rest, why is it that consultation was not done? I'm just thinking, Advocate Mutlamunyane was leading, and then you have the 3 of you sitting here, And then at one stage you asked to be excused, and I'm trying to think, to understand, why is it that whilst you were presented with Advocate Batoi's statement under oath, little seems to have been done. Very little, it appears. Over a period of a month, maybe I should say that, or closer to a month. And now we have to take a week's adjournment according to your request.
Yeah, well, as far as that is concerned, and may I also indicate, insofar as our juniors are concerned, that's now me with Advocate Mhlamunyane, I fully take the blame that we gave them. I thought that we were going to have these witnesses, and I kind of gave them assurance, taking from the relations and the communication with these witnesses, that really you may consult, but take your time, prepare yourself, but these are the two witnesses that you're going to call, and they may take over this kind of time. So on that basis, I think I take the blame there. Maybe I should have insisted that they must proceed and consult as quickly or as urgently as possible. And that did not happen, for which I profusely apologize. Perhaps we could have done better. But where we are now, we have now this situation where we don't have a witness who can testify immediately. And one must keep in mind that there is also some form of agreement between the parties to share witness statement. In other words, whoever needs to be called next, we need to present a statement in advance for that. So that's another aspect, Madam Chair, that should be taken into account. That in our request for a week is that there will need to be a statement prepared and given to the other team. And I also must mention that while we know that the issue about the evidence of Advocate Batoi started on the 15th of December, and perhaps one could have anticipated that she might not come back, but the developments continued. And if I'm correct, the last development when the minister said finally decided on the appeal was on the 8th of January, if I am correct, which really then started putting more pressure on. Now it looks like the issue of her acquiring that legal counsel that she had asked for is coming to fore. It looks like it's not going to happen, and that might create problems for this inquiry. I just wanted to bring that in, that's one element that must be taken into account, that there is a date of 15th December, which we acknowledge and we accept, but there are quite a few developments that took place that need to be taken into account.
You are stating that what would have caused problems for this inquiry?
No, I was mentioning only that we know that on the 15th, after the 15th of December, there was then an application by Advocate Batoi, although we haven't seen that application, for the appointment of a team, a legal team.
A request. It was a request to the
well, yeah, I said an application, a request,
the state attorney,
yes,
and to the minister.
Later
There was no
to the
application
minister.
before us.
Yes. All I was indicating is that issue and the final outcome of that came after the minister had decided. That is now on the 8th of January 2026. And of course followed by what we have now found about the possible conflict of interest as well. I'm just mentioning that those are factors that one should take into account.
So, according to what you've submitted, you interviewed 2 witnesses and they collapsed. We have communication from Major General Boysen, and he says he'll only be available towards the end of February. And then the remaining witnesses have not been consulted.
That-
Now,
that's the essence, yes.
you are here now asking for a stand down, a pause, a postponement. But one can't avoid wondering that what happens after the week that you would have requested, say that request is granted. Would you have witnesses then, or we are going to sit again the whole day having a conversation with the inquiry being put on pause? Because as it is now, you do not have a witness statement that is almost ready. And from your correspondence that we've seen, you were supposed to have exchanged witness statements by the 19th. When was the 19th? Last week, Monday. And it didn't happen. And we are here, today is the 26th. You want us to come back next week, which is February. I'm not sure what is the date next week, Monday. But will we still be in the same position, or the position would have changed? Let us not put Advocate Batoyi into the equation, because her issue is a different issue. I'm talking about the evidence leading team and the evidence that they are supposed to lead here through witnesses.
Well, maybe to start with the date of 19 January, that date was not a date on which the parties agree. And I'm not saying it was unreasonable for the Advocate Chauke's team to suggest that date. But we could not agree for the exchange of witness statement. We don't agree, particularly because of the difficulties that we're experiencing with our witnesses. We could not agree to that date. As far as the second question about whether by Monday we would be ready, I have discussed that with my team, and I was given an assurance. Of course, one takes into account that if an individual or a witness says, I can't consult, or I'm not available on this particular date, might create difficulties, but that we will be able to have a witness by Monday to continue in the event that there's still issues about the evidence of Advocate Batoyi. Would be able to have a witness to continue with this inquiry on Monday.
Advocate Skosana, maybe let me ask Advocate Mohlamunyani, because you correctly point that when you came, the train was already moving. He was at the helm as the chief evidence leader. I take it, Advocate Mhlamunyani, if you are able to listen as you are moving about. Have you been listening?
I've been listening.
Okay, thank you. Now, I take it that you work as a team, irrespective of who arrived when, but otherwise, as the team was growing, you continued to work as a team. Is that a correct assumption?
It is, Madam Ramagaga. It is correct.
Right. Thank you. Now, maybe let us first talk about the witnesses or the persons that you have identified as witnesses to this inquiry. Am I correct when I say that the caliber of persons that you have identified as witnesses and appear on your list of witnesses, they are not lay persons. They are persons who can be assumed to be having reasonable knowledge of what is expected of them. Will that be correct? Generally speaking, remember I said
Generally speaking, Madam Ramagaga, that is correct, save for 2 of them. But generally speaking.
qualifying it with generally. Right, thank you. Now, because the main crop seems to be the understanding crop, moving forward, questions that I'll ask will be taking that into consideration. Now, the caliber of those persons is such that they do qualify to assist in developing the draft statements that you would then work on and maybe improve on them in due course. Is that correct?
That is correct, Madam Ramagaga, and perhaps I should indicate to you at this stage, with your permission, what I encountered with my witness, and I'm going to be very direct.
Would you prefer to deal with that first, or should I finish and then you can?
You may finish, Madam Ramagaga.
Right, thank you.
I'll deal with that later.
Yes. Thus far, we are in agreement that they could and they have the capacity to develop the draft statements, which you could then work on and improve on.
Yes, generally.
Thank you. And before you put the names of those persons in the list of witnesses, did you speak to them? And when I say did you, I'm talking about you as a collective, understanding that you are at the helm and you engage and set rules on how to do things. Did you engage? The answer, if it's unison, it'll be yes or no. But if each has his or her own answer, you'll answer on behalf of each, indicating that this one has experienced this or this one has not contacted them at all, or so forth. What is the state of affairs?
Let me indicate to the panel, Madam Ramagaga, that I was being assisted by Advocate Hali SC in identifying the witnesses.
Mm-hmm.
And before I was joined by the team, as you see it, I already had certain witnesses, potential witnesses, who we will need as evidence leaders to come and testify and assist this inquiry.
Mm-hmm.
After doing so, I then prepared a list. And I must point out at this stage that I prepared that list without consulting those witnesses, without inquiring from them as to whether they will be prepared to testify or not. I was just working on the basis that they are potential witnesses. And in the event that a witness refuses to come and testify because we do not have, as an inquiry, subpoena powers, we will then inform the panel and our opponents and the Chauke team that such and such a witness who we have identified has reneged or has decided not to testify. Now, after having done that, after being joined by the rest of the team, the evidence leaders team, we were then allocated specific witnesses. And I was allocated at General Johan Boysen. I must mention at this stage that General Johan Boysen, as far back as November, December, had prepared draft statements for us. After consulting, after interviewing him and talking to him in Cape Town on or about the 6th of November, if my memory serves me well, 6 November 2025. And indeed, he promised to send draft statements. Indeed, he did so until he gave us a final one. Now, some time ago, a few days ago, maybe 2 weeks ago, I started working on the last draft. And I called him last week and to say to him, General, I'm working on your statement, the last one that you sent to us. He sent the statement to me and Advocate Hali SC. I said to him, I'm working on that statement. I'm trying to finalize and settle it. And I am of the view that you and I should sit in Cape Town. I'll fly down to Cape Town on 2 consecutive days to finalize your statement. We were agreeable about that. I extended an olive hand to him and said, your lawyer or your advocate can be present if she wishes or if they wish. I don't have a problem with that. And he offered to give me, rather, let me correct myself. He asked me as to whether he can give my mobile number to his advocate. I said, yes, you can do that. And then we got into a conversation with his advocate. And his advocate indicated to me that they are working on his statement. Yes, they are working on this statement. I said, I've already started working on that statement. She said, no, we are working on that statement because our client's rights have been trampled on and no one has protected our clients, and our client has to be protected. After speaking to her, I then reverted to General Boysen to say, General Boysen, I'm in this situation. Your advocate is saying 1, 2, 3 to me. Now, I want to find out from you as to whether you would still come to the inquiry to testify. He emphatically indicated to me that he is prepared to testify. He doesn't want to be seen to be a recalcitrant witness. But he has concerns. His concerns are the Danikas issue. The Danikas clips that were flighted on air, and everybody else in South Africa has seen that, and it paints a very bad picture on him, and he wants to deal with that in his fully, decisively, in his affidavit. And he's saying to me that in the course of doing that, he has documentation, some of which is not currently in his possession, is lying around elsewhere, and he still has to get it.
Trying to just indicate that, remember that now I'm not looking for full information.
Yes.
At least you are giving the panel an idea about General Boysen in particular. But the main gravamen of my questions is to check about whether capacity to develop draft statements, and you have illustrated in your address that yes, there are some of them, of course, and General Poison is one of those that have participated in the evolution of the draft statement thus far. That is correct.
That is correct, but
Yes.
with the assistance,
With the assistance of his legal
team.
representative, which is fine.
Yes.
Yes. Now, is he the only person that you have consulted with, or from whom you have sought a draft statement, or what is the position?
so far, yes, Madam Ramagaga. That is the only witness that I consulted with, that I contacted, apart from initially contacting Advocate Molochwa when I was still alone here. Before I was joined by my fellow colleagues.
Okay, yes,
Yes.
we'll come back to that if necessary. I'm still on the issue of just general questions. Now, the witnesses that you have identified, or persons that you have identified as witnesses to this inquiry, was that list drawn from the names that appear in Advocate Batohi's affidavit or evidence, or are they also constituted of any persons who could have made representations out of interest? What is the position? Is it exclusively from the affidavit, or is it a mix of things? And if it is, please indicate. Thanks.
It is a mix of things, and I'm not able to say which ones have did Advocate Batohi mention in her affidavit. But the majority of the witnesses who are on this list was through the help of Advocate Hali SC, who helped me to identify a witness by telling me that this one is relevant. Look at document XYZ or documents XYZ about this witness is relevant on this aspect. And some of the witnesses I identified myself. But in the main, I was assisted by Advocate Hali SC.
Okay, that's fine. At the beginning, when I started asking you questions, you wanted to talk about whether it's a particular witness or witnesses, remember? Have you addressed that in your answer, especially that long answer, or do you still want to talk about what happened? Yeah.
Not quite. I think I've addressed the issue of Advocate Johan Boysen. I'm sorry, not Advocate Johan Boysen, General Johan Boysen, adequately. He says to me, if I, without being seen to be repetitive, he's prepared to testify, but he can only do so at beyond February, because even his lawyer, his advocate, is indicating to me that that statement will only be available at the end of February.
Okay, thank you. But then you also mentioned right towards the end, you mentioned Advocate Molochwa.
Yes, Madam Ramagaga, I did mention Advocate Molochwa.
Yeah. Is there anything that you want to say
About
her availability and draft statements or so?
Let me indicate this at the outset. This inquiry started on the 17th. We started on the 17th of November 2025. And if I'm not wrong, Advocate Batohi started leading her evidence on the Wednesday of that week. On the Saturday, I picked up a phone and spoke to Advocate Molochwa with a view to find out about his availability for a consultation. The Saturday, the 22nd November. Advocate Molochwa was more than willing to testify. What he indicated to me as his problem was that he no longer has in his possession his statements. And he asked me to send him his statements that he made when he testified in the Mokoro inquiry and the Zondo Commission. And I made them available to him. He even sent me clips when he was testifying. And I conveyed that to my co-evidence leaders when they joined me. I also indicated that to Advocate Hali. And today, the situation is different.
What is the state of affairs? What has changed?
What has changed is what Advocate Themba Skosana has indicated to the panel, that Advocate Molochwa is now giving several reasons about his unavailability during the course of this year. One of his reasons why he will not have time, if I may use that pun, to come over to testify in this inquiry is that, one, he's preparing for the 7th, I think, I'm speaking under correction, 7th Comrades Marathon. 2, he has registered a master's degree with one university, I believe it must be one of the universities in KZN. Another reason is he is saddled with matters, his own personal matters that he deals with as a practitioner. He's now in private practice. He's a member of the Pietermaritzburg Bar in KZN. And that he will be having matters, his hands will be full, so to put it, and he'll not be able to assist.
Okay, thank you. So thus far, is the witness, is General Poison the only witness that you can tell us is available for the Katomeina issues? Or is there another one that you can say, as far as I'm aware, this witness or these witnesses are still committed to the cause?
One of the witnesses that I believe is still committed to the cause is Advocate S. Riley, and she has been allocated to Advocate Mutsweni. And I've given Advocate Mutsweni her mobile number, which I asked from the NPA team. And as soon as I believe we leave this chamber, he'll get in contact with her. The next one is the one allocated to me, General Nhlanhla Mkhwanazi, whose evidence, according to what we have, will not be long. And I said to myself, well, this one will not be long. I'll see him later after I shall have dealt with the General Johan Boysen's issue. So I parked it, maybe at my own peril, or at the peril of the panel, the evidence leaders. I just parked it because I wanted to first deal with, because I thought he will not be a complicated witness. But maybe upon hindsight, because I should not have acted in the manner in which I acted. I should have consulted him. Upon hindsight, I realized that.
No, thank you very much, Advocate Mohlamunyane.
Thank you, Madam Ramagaga.
I'm making just a general statement to the evidence leading team. You were appointed by the President to execute your function. And if the witnesses or potential witnesses who are officials in the NPA makes it difficult for you to execute your function, shouldn't you place that in writing and address that to the minister? That we have been given this task, we are not able to perform our function because of this, that, and that, and that, especially the witnesses who are officials or advocates in the NPA.
May I answer, Madam Chair?
Yes, I just want to know.
Yes, you are correct, Madam Chair. that would be ideal. That would be a proper position to take to inform the minister about the hindrances that we encounter. But in this matter, about these two witnesses that Advocate Skosana SC has referred to, one is Advocate Simpiwe Cyril Molocho, who's no longer in the public service. He's in private practice now. I'm not sure whether we can report him to the minister. The second one is Advocate Muiponi Nogu. She's also the former DPP of KZN. In 2012, thereabout, she was appointed the DPP. And as indicated already by Advocate Skosana SC, she was willing to testify, but she has changed colors now. I wonder whether it will be appropriate to report them to the minister. They are no longer in the public service, Madam Chair. Thank you.
Nogu
Yeah, Advocate Nogu is no longer in the public service. She has resigned.
and Advocate Mlochwa.
Advocate Mlocha is in private practice now. He's in private practice as a member of the Peter Marisbeck Bar.
I'm not thinking in terms of reporting as such, but just placing information before the minister. Because at a critical time, these advocates served under the auspices of the department. Not necessarily that they be investigated, but just to place information for the minister to understand the challenges you are confronted with as evidence leaders.
I agree. I'm inclined to agree with you, Madam Chair.
I may be wrong,
to
but
raise
it's a
the concern.
matter that on your own you can consider.
We will indeed consider that. Thank you, Madam Chair.
Maybe just to add, although they are in private practice, but they are within a regulated space.
Yes, of course,
So,
Madam Baloimere.
so you can deal with them within that regulated space.
Especially that they are members of the LPC, Legal Practice Council. I'm not sure about Noko, but she's still an advocate. She's still holding the title of advocate.
As long as she still holds,
Yes.
she is a member of any legal practitioner in South Africa is regulated by the LPC.
Indeed.
So you can deal with them within that space.
We will do that. We'll consider that. Thank you, Madam Baloimere.
That said, what is your final proposal, Advocate Skosana? I know that you have intimated that Advocate Hali might want to say something,
Yes.
but from your side, what is the final proposal you wish to make to us for consideration?
Madam Chair, our proposal is that we request the postponement or adjournment of these proceedings until Monday, and on the basis that on Monday we should, and perhaps Advocate Harley will touch on that if he's given an opportunity. On Monday, we will have some headway insofar as the issue of the evidence of Advocate Batohi is concerned, number one. Number two, if not, if Advocate Batohi is unable to continue with the testimony by Monday, we will make sure that we have a witness to continue giving evidence before this inquiry.
I'm making an undertaking that if Advocate Batohi's issue is not resolved or she's not able to take a witness stand, you as evidence leaders will be ready to proceed.
Yes, indeed, we are making that undertaking.
Supposedly, you would have exchanged the witness statement in advance with the Advocate Chauke's team.
Yes, Madam Chair, would at least there would be witnesses' statements maybe not all the statements, but there should be a statement of a witness. The witness we would have prepared for Monday will have the statement of that witness. Also
The question
shared.
is whether you would have exchanged the statement that is available with the Advocate Chauke's team in advance, probably on
Yes.
on Friday. If we are to proceed on Monday with that particular witness, I'm trying to make sure that you are making this undertaking seriously, understanding that the other side must have had a side of the statement.
Indeed, Madam Chair, the undertaking is to also share that statement of that witness in advance before Monday.
Thank you, Advocate Kosana. Thank you, Counsel, all of you. Advocate Goitobi.
Madam Chair, I suppose there's very little for me to say at this point, other than to ask who.
Do you know Advocate Kosana, or do you have an idea, more or less?
Chair.
In which event the team for Advocate Chauke will assess its position and decide what they want to do. Advocate Riley, they say.
Thank you, Madam Chair. I suppose it also comes with the under.
Say something. You may come forward, Counsel. I know that there is another, you can shift a bit. Yes, thank you.
Thank you, Madam Chair. There is no burning desire on my part to say anything per se, other than to explain what our position is. So, what we had requested from the panel, pursuant to a letter which was addressed to you, Madam Chair, as the chairperson of the panel, was a request to allow us to consult with Advocate Batohi while she was under cross-examination in order to advise her. The context to that, much of which has already been canvassed, was that we were initially briefed to act on behalf of the NPA. Those instructions were given to us by the state attorney, and I imagine that it came from the exco of the NPA, which would have included, amongst others, Advocate Batohi. When Advocate Batohi, on the 15th of December, stood down in order to seek legal counsel, her desire was to seek the advice of counsel other than myself and Advocate Lekgetho. We, myself and Advocate Lekgetho, had initially been briefed, as I said, on behalf of the NPA. You may well recall from previous exchanges that we had that I was at pains to point out that we were acting for the NPA and we were not part of the evidence leaders team. At any rate, all of that culminated ultimately in the request by Advocate Batohi to the state attorney to have the counsel that she wished to have appointed to assist her in giving advice pursuant to the indication that she had given to the panel on the 15th of December. That request, as I understand it, ultimately percolated up to the level of the Solicitor General, who declined to make the appointments. Reasons were given, and the Solicitor General concluded by stating that she had the right of appeal and she should appeal to the Minister. The Minister was then, after, as I understand it, after some further correspondence was exchanged with the Solicitor General, the Solicitor General indicated that he stood by the decision that had been taken. What then transpired was that Advocate Batohi then appealed to the Minister, and the Minister's response was that there should be a consultation, that she should rather seek the advice of myself, of me, and Advocate Lekgetho. After considering the correspondence, we decided to write to the panel, as I've indicated, to make the request to the panel that we should be allowed to consult with her, because it was anticipated that we would need to consult on matters that may well involve issues that were canvassed during the course of of cross-examination. Now, subsequent to that, and nearing the present date, it became, I certainly had occasion to reflect upon this, and how would I be able to consult with her, and how would I be able to properly address some of the issues that were reflected in the request to the state attorney, it seemed to me that it was inevitable that a conflict of interest was going to arise on the one end between Advocate Batoy and the various options that may confront her, and the NPA. Bear in mind that my brief came to me to represent the NPA, not to represent Advocate Batoy, and that her request had been made initially for other counsel to represent her. Now, it was in that context that we approached the panel this morning and indicated that we believe that we are heading inevitably towards a conflict of interest. We would not be able to properly discharge our mandate to either one of those clients to be able to canvass every aspect that was in the best interest of either one of those two clients. Now, at the moment, we are unable to take instructions from our client, which is the NPA. Until now, our client has been represented by Advocate Batoy, as well as the EXCO. So where necessary, I've had to take instructions from the EXCO. But since the latter part of last year and the early part of this year, that EXCO has been somewhat denuded of some of its members. Some of the members have fallen away. They've either resigned or retired. I stand corrected. I don't know which. And at least two of them are simply acting members. So the upshot of it all is simply that they are unable to provide me with instructions, even if they were desirous to do so. It's possibly in the context of that, having explained it to the evidence leaders, it's possibly in the context of that the suggestion was made that we should stand down until Monday, because Monday is the date on which the new National Director of Public Prosecutions takes office. But I don't anticipate, and I don't wish to comment necessarily on the stance adopted by the evidence leaders, but I certainly don't have the confidence necessarily, because I simply haven't spoken with the new National Director of Public Prosecutions, whether he would even entertain my presence on Monday. So that's something that still has to happen. So I can't give any undertaking as to when that would happen. My experience, having worked with different organs of state and different departments, my experience has always been that I'm going to be requested to provide some kind of a memorandum in order to bring the individual who's going to have to take the decision up to speed. I anticipate that that would happen with the new National Director of Public Prosecutions. To put together, and of course at this stage I simply haven't been asked to put together anything, not a memorandum or otherwise. So I'm still hoping to get an audience with the new National Director of Public Prosecutions. I might be, I'd like to think that I would be a priority for him, bearing in mind the circumstances of this matter. But I haven't spoken with him, and I'm not in a position to comment either way. So that's the position where we find ourselves in, and my position applies equally to my junior Advocate Lafeto. There was a question that was posed, if I recall correctly, by Advocate Baloyi Mary, as to whether, when the minister had been approached, had she been approached about the potential conflict of interest? The short answer to that is no. But there were certain aspects of the minister's letter that I thought may require me to revert to her, if I was permitted to do so. The one concern that we had when we considered whether we ought to go back to the minister was we had no understanding of the regulatory framework that gave rise to the minister's position as the appeal body. So we read through all the legislation, the State Attorney Act, we read through the regulations, and we read through the through the policy that we had been referred to. We were unable to find any particular document or instrument that could talk to the question of whether the minister was functus officio, as it were. So we did consider the possibility of going back to the minister, not specifically on the question that was raised, but on certain other aspects of the letter. But that's as far as we could take it. That's where we stand at this point in time.
Now, given the fact that a decision has been taken already by the minister, assuming she had no power to decide on the matter, if she is functus officio, but a decision has been taken, will there be any harm in you and your junior or even the NPA presenting this difficulty to the minister that you anticipate? Because as I understand the correspondence, the minister decided on the basis that you and the junior are here and you could represent Advocate Batohi at the personal level. That's how I understood.
That is correct, Madam Chair.
Yes, the correspondence. But if the minister is to be advised that the converse is true, you are actually not in a position to represent her because of this potential conflict, a matter which was most probably, as I understand now, not brought to her attention. That might just resolve this whole conundrum. And the minister may revisit whether she is functus or not. She may just maybe reflect, or the Solicitor General himself may even reconsider the position and decide otherwise.
Madam Chair, it can't do any harm to revert to either one of them. It would seem to me that given the level to which it has advanced, the appropriate person, if we are to go back, the appropriate person to go back to would be the minister now that she is seized with the matter. As I said, this issue arose, the question of the conflict of interest arose fairly recently. So up until last week, it wasn't always apparent to us that there would have been a conflict of interest. It was upon reflection that we came to appreciate that there would be a conflict of interest.
Yes, and if I may guide.
But I take your point, if I may conclude, I take your point.
Yes,
and certainly during the course of the debate between the panel and the evidence leaders team, it struck me as being a rather sensible approach to adopt.
Council, if I may guide, if you may consider that approach, that the new NDPP has not taken office as yet. As we speak, Advocate Batohi is still the NDPP. And also given the fact that these are polycentric issues that will entail a decision made or to be made by a member of the executive. You know, when you talk money in government, especially because the NDP or NPA falls within the auspices of the department, of the ministry. Am I right?
So
I'm not sure whether I'm putting it correct, but it is an institution in respect of which the NDPP works hand in hand with the Minister of Justice.
That is so, Malady. If I understand correctly, functional responsibility ends at the National Director of Public Prosecutions, or operational responsibility. But insofar as the responsibility for finances are concerned, that responsibility ends with the Department of Justice.
Yes. The issues that we are dealing with now concerns finance, budgetary matters, and the minister seems to be the right person to go to insofar as Advocate Batoi's request is concerned. So if it is discovered, as you'll be talking to one another, that there is a conflict of interest, a matter that might not have been brought to the table of the minister, or even the Secretary General, Solicitor General.
The Solicitor
rather.
General.
The Solicitor General may reconsider, the Minister may also reconsider, and we may not even be here now. We should have made a headway. So it seems to me that on the challenges that you and your junior are confronted with, which is quite understandable, perhaps now that the Minister has decided that you must represent her or consult with her, and you are now confronted with all these sorts of legal challenges, because even if you were to be appointed to represent her, the question that then arises is whether you have a right to consult with her on matters that arise during consultation, cross-examination. That opens all other difficult challenges, as you know. So it seems to me that the buck stops with the minister. And if she is to appreciate these challenges that you are placing before us, she may just as well decide otherwise. A week, I'm not sure, but it seems to me that the first person to communicate with is the minister, because the new NDPP has not assumed office. Advocate Batoi, you cannot talk to her. She's the NDPP, but because of these issues that you are grappling with, you cannot talk to her. And the minister is the last place to go to if the Solicitor General does not give you Audi, and he thinks that you are not entitled. I'm sure you'll start there, and then the matter will then go to the minister. He's here, you can discuss the matter without necessarily having to write letters to each other. And I'm sure the Solicitor General appreciate the very challenges that you are presenting to us. No, thank you. I'm not sure whether my sisters would like to ask you any question.
I have just one. I'm sorry, I thought I would keep quiet because it's late in the day, but I can't help myself. You painted a picture that it seems like literally EXCO within the NPA does not exist anymore. You said some have left and some are acting.
Two of them are acting. That is correct.
Acting. And how many have left?
If I understand correctly, one is left, and Advocate Batoy is the other one.
Yeah. How many?
I
how many members?
I think there may be one vacancy. I think there were supposed to be 4. I stand corrected. 4 Deputy National Directors of Public Prosecution, all